Okay, let's unpack this. Imagine a legal battle so profound, so deeply resonant, that it shapes the very fabric of a nation's democracy for generations. A case that dares to ask a truly fundamental question. Can a country's founding document be changed entirely, or are there some core principles, some essential features that are just, untouchable, sort of an immutable bedrock? Today, you and I are diving deep into precisely such a monumental legal saga, the 1973 Kesavananda Bharati v. State of Kerala case. This landmark judgment, delivered by a record-breaking 13-judge bench on April 24, 1973, isn't just some legal curiosity. It is widely considered the bedrock of Indian constitutional law, a real turning point. The central question for you, our listener, cuts right to the heart of ultimate power in a democracy. Who truly gets the final say over the Constitution? Is it Parliament, representing the people's will today, with the power to adapt the nation's framework as it sees fit? Or is it the Constitution's original framers, whose vision is protected by the judiciary, tasked with safeguarding its enduring principles against, well, fleeting majorities? This isn't just some dry legal ruling, you see. It's a gripping narrative. A constitutional chess match involving a solitary religious leader, sweeping land reforms aimed at social justice, and the very philosophical definition of what a constitution truly means for a diverse nation like India.
The critical aspect to consider here, I think, is the sheer scope of this case. It didn't just interpret existing law, it essentially created a brand new doctrine, a doctrine that acts as a perpetual guardian for the very soul of the Constitution. Our mission in this deep dive is to meticulously navigate the intricate arguments presented by both the petitioners and the respondents, to explore the diverse and often conflicting opinions of those 13 judges, and to distill why this case is considered so foundational to Indian constitutional law. Crucially, we'll uncover what this means for every citizen, helping you understand the complex and often dramatic interplay between legislative power, your fundamental rights, and the judiciary's vital role in maintaining a vibrant democracy.
Right. To truly appreciate the gravity and lasting impact of Kesavananda Bharati, we first need to rewind a bit. We need to understand the constitutional landscape that existed before it. Think of it as observing the early chapters of a long-running legal drama where the rules of the game were still, well, being defined. At the heart of this unfolding story is Article 368 of the Indian Constitution. That's the provision specifically outlining the process for amending the Constitution. In the early days of the Republic, this article was primarily viewed as a procedure, just a set of steps to follow to change the Constitution, rather than an unlimited source of power to alter its very essence.
Exactly, and that initial interpretation is key.
Our first crucial stop is a case from 1951, Sankari Prasad Singh Deo v. Union of India. This was one of the earliest tests of Parliament's amending power. Here, the core idea the Supreme Court laid down was that Parliament possessed a wide-ranging power to amend the Constitution, and critically, this power included the fundamental rights enshrined in Part 3. The key ruling, and this is vital, was that a constitutional amendment is not considered a law within the meaning of Article 13.2. Now, Article 13.2 is super important for you, the citizen, because it unequivocally prohibits the state from making any law that takes away or bridges any of your fundamental rights.
Precisely. By ruling that an amendment wasn't a law in the context of Article 13.2, the Supreme Court essentially created a kind of legal firewall. They concluded that fundamental rights were indeed amendable. Imagine an ordinary law as a rule within a game like, say, no tackling above the shoulders. Article 13.2 said, you can't make a rule that infringes fundamental rights. But a constitutional amendment, the court argued in Sankari Prasad, was like changing the rules of the game itself, maybe saying, from now on, the game has 3 halves instead of 2. Okay. And if Parliament was changing the game itself, then the old rules about protecting fundamental rights from laws didn't apply. So for nearly, a decade and a half, this meant Parliament could alter virtually any part of the Constitution, including those fundamental rights guaranteed to you.
Yeah, that initial interpretation gave Parliament immense flexibility, maybe what many believed was near absolute power. But as a nation matured and socioeconomic challenges grew, subtle questions began to emerge about the wisdom of such an unfettered amending power. Is it really unlimited? These questions started bubbling to the surface in Sajjan Singh v. State of Rajasthan in 1965. This case largely reaffirmed the Sankari Prasad ruling, upholding Parliament's broad amending power.
Right, but the real significance of Sajjan Singh lies not in its majority decision, I'd argue. It's in the powerful dissenting voices that started to question this seemingly unlimited power. Justice Mudholkar, for instance, made a very profound observation. He noted that the preamble of the Constitution has the stamp of deep deliberation, and he hinted that the framers attached special significance to it.
Think so.
It was subtle, sure, but a crucial hint. a seed of an idea perhaps that there might be inherent, maybe even unwritten, limitations to the amending power, even if they weren't explicitly spelled out in Article 368 itself. He raised the question, could basic features, even without specific mention, be beyond amendment?
If we connect this to the bigger picture, then, these early cases were really laying the groundwork for what would become a major constitutional crisis. The government, particularly under Prime Minister Indira Gandhi, was increasingly focused on implementing extensive socioeconomic reforms. Big stuff. These included sweeping land redistribution programs and the nationalization of industries like banks. These ambitious reforms, while aimed at achieving social justice, frequently clashed head-on with individual property rights, which at that time were enshrined as a fundamental right under Article 31. This clash, this inherent tension between the collective good and individual liberties, was definitely building up.
Indeed it was. Parliament felt its mandate from the people required radical action to alleviate poverty and inequality. But the judiciary, interpreting fundamental rights strictly, often became an impediment, right? Standing in the way. This direct confrontation over the extent of Parliament's amending power wasn't just theoretical. It was delaying crucial government initiatives. This tension wasn't merely building. It basically exploded in the next major case. It really set the stage for one of India's most significant constitutional battles. It was clear that the matter of Parliament's amending power was far from settled. A decisive confrontation was looming.
And that, my friends, brings us to I.C. Goloknath v. State of Punjab in 1967. This was the brewing storm that completely shifted the constitutional landscape, just turned everything upside down. The big question before the Supreme Court was unambiguous. Can Parliament, using its power under Article 368, actually abridge or take away the fundamental rights guaranteed to citizens? The Supreme Court delivered a stunning, closely divided split decision, a narrow 6.5 majority that truly rocked the boat. It left legal scholars and politicians alike scrambling to figure out what it all meant.
It really did. A very narrow margin for such a huge decision.
The leading majority view in Goloknath, championed by Chief Justice Kesavananda and 4 other judges, took a truly bold stance. They argued that the power to amend the Constitution is not actually found in Article 368 itself. They contended that Article 368 merely provides the procedure for amendment, just the steps. Instead, they traced the source of Parliament's amending power to Article 248, which deals with residuary legislative power, read with entry 97 of List 1 in the 7th schedule, basically, general lawmaking power. Because they saw the amending power originating from a legislative article, they concluded that a constitutional amendment is indeed a law under Article 13(2). And if an amendment is a law, then, by definition, Parliament simply cannot abridge or take away fundamental rights. Full stop. This was a profound reinterpretation, effectively putting fundamental rights beyond the reach of Parliament's amending power.
What's particularly insightful here, I think, is the nuanced difference even within that majority. Justice Hidayatullah, while concurring with the outcome that fundamental rights couldn't be abridged, offered a slightly different, maybe more philosophical reasoning. He viewed the amendment power not as ordinary legislative power, but as sui generis, unique, right? Meaning of its own kind, or in a class by itself, igle. Think of it as a special higher power that exists outside the conventional categories of lawmaking Parliament usually engages in. And because it was so unique, so fundamental in nature, he argued it couldn't be used to dismantle the very core protections of the Constitution itself. He asserted that fundamental rights were eternal and inviolate, declaring them not playthings of a special majority. He even questioned the idea of amending the preamble without consulting the states, further hinting at inherent limitations that transcend explicit text. His argument laid a more philosophical groundwork for protecting fundamental rights.
Interesting. So different paths to the same conclusion within the majority.
Exactly. And then on the other side, you had the powerful minority view, led by Justice Wanchu and 4 other judges. They steadfastly adhered to the earlier interpretation from Sankari Prasad and Sajjan Singh. They argue that both the power and the procedure to amend are unambiguously contained within Article 368. Simple as that. They firmly rejected the idea that a constitutional amendment is a law under Article 13(2), emphasizing that amendment meant a comprehensive power to alter, add, or delete any provision of the Constitution. To them, the Constitution was meant to be flexible, to evolve with the times. Reading implied limitations where none were written. That would be judicial overreach, undermining the democratic will expressed through Parliament.
And here's where it gets really interesting, a bit of a constitutional paradox, isn't it? Even though the majority in Golok found that fundamental rights were unamendable for the future, they introduced something called prospective overruling. Claude. This meant that while Parliament couldn't make new amendments that violated fundamental rights, past amendments like the First, Fourth, and Seventh, which had already affected fundamental rights, remained valid. What exactly did that mean, and why was it so vital for the court to take such an unusual step?
That's an excellent question, and it really speaks to the court's pragmatic wisdom, I think. Prospective overruling is a legal doctrine where a court's decision in a case applies only to the future. It doesn't affect past actions or judgments. In Goloknath, it was a deliberate and, frankly, necessary judicial maneuver to avoid throwing the existing legal system and maybe the entire nation into utter chaos. Imagine if all past amendments impacting fundamental rights had been suddenly invalidated. It would have undone decades of legislative action, potentially destabilizing land reforms, nationalization efforts, countless other laws that had been enacted and relied upon. So while the court asserted a new, stricter interpretation for the future, it carefully preserved the legal validity of the past. It was attempting to balance legal principle with social and governmental stability.
Right, okay. Damage control, in a sense.
You could say that. A way to make a principled stand without causing complete upheaval.
As you can imagine, this case created immense uncertainty and deep-seated frustration within Parliament. Just huge frustration. Parliament felt its power, its very ability to implement the social and economic reforms it considered essential for national progress and to fulfill its mandate from the people, was being severely curtailed by the judiciary. This direct and dramatic clash between the legislative branch's intent and the judicial branch's interpretation wasn't merely a legal debate. It was a political confrontation that threatened the balance of power. This situation, where the highest court had drawn a line in the sand, really set the stage for Parliament to respond decisively. It was clear this was not the final word. A major constitutional showdown was now not just inevitable, but imminent. Indeed, the political temperature was soaring, and it was into this crucible of escalating tension that Parliament plunged headfirst, their response. A direct, unambiguous countermove to the Goloknath ruling, passing the 24th Amendment Act in 1971. This wasn't just another amendment, this was Parliament's explicit attempt to assert its supremacy. To definitively clarify, from its perspective, its unquestionable power to amend the Constitution, it was, in essence, Parliament saying, we do have the power, and we're going to make sure the text of the Constitution explicitly reflects that, leaving no room for judicial reinterpretation.
A very clear message.
Let's look at the key changes introduced by this 24th Amendment, because they were quite comprehensive and aimed directly at dismantling the Goloknath verdict. First, they revised Article 368 itself. The marginal heading, which previously simply read Procedure for Amendment of the Constitution, was pointedly changed to Power of Parliament to amend the Constitution and procedure, therefore. This was a crucial and deliberate linguistic shift, explicitly stating that Article 368 confers power, not just procedure, directly addressing one of the core points of contention from Goloknath, Parliament asserting its authority right there in the heading.
Absolutely. And the actual text within Article 368 was also meticulously revised to reinforce this message. Parliament added the phrase, Parliament may, in exercise of its constituent power, amend, by way of addition, variation, or repeal any provision of this Constitution. This clarified two vital things. One, it made it unequivocally clear that the word amend had a wide scope encompassing not just minor alterations, but also additions, variations, or outright repeal of provisions. Two, and perhaps even more significantly, it explicitly stated that Parliament acts in a constituent capacity when amending the Constitution. This distinction is crucial because it differentiates the act of constitutional amendment from ordinary lawmaking.
They also made it obligatory for the president to give assent to a constitutional amendment bill. That was new. Prior to this amendment, presidential assent wasn't explicitly mentioned as obligatory for constitutional amendments. This streamlined the process, removing a potential hurdle and any discretion the president might have had to withhold assent on an amendment bill. But perhaps the most direct strike against the Goloknath ruling was the addition of Article 13.4. This new clause explicitly stated, nothing in this article shall apply to any amendment of this Constitution made under Article 368.
That new clause, Article 13.4, was Parliament's clear legislative maneuver to nullify the Goloknath ruling, just wipe it off the books, legislatively speaking. By declaring that constitutional amendments were not laws under Article 13.2, they aimed to remove the basis on which the Supreme Court had previously limited Parliament's power over fundamental rights. It was a direct legislative override, an assertion that Parliament's constituent power was superior to and distinct from its ordinary lawmaking power. And thus, constitutional amendments were beyond the scrutiny of Article 13.
So, what this all means for you, the citizen, Imagine Parliament, after being told no by the courts in Galeknath, then turning around and essentially saying to you, "We, your elected representatives, have the ultimate authority to shape your nation's future, and no court can stand in our way. Your fundamental rights. We can amend those too if the nation's progress, as we define it, demands it." This amendment was Parliament's way of emphatically stating, "We do have the power to change anything we deem necessary for the nation's progress, and the courts can't use Article 13 to stop us." Hey, it was a bold attempt to regain the ground they felt they had lost to judicial interpretation.
This raises a very important and central question, doesn't it? Did the 24th Amendment truly enlarge Parliament's power, or did it merely clarify what the framers originally intended for Article 368? In Kesavananda Bharati, most judges, interestingly, even those who would eventually go on to establish the basic structure doctrine, found the 24th Amendment to be valid. They generally agreed that Article 368 does contain both the power and the procedure for amendment, and that Parliament exercises constituent power when amending, making it distinct from ordinary legislative law. So they acknowledge Parliament's right to define its amending capacity, at least textually. So Parliament framed it as a clarification, right? Saying they were merely restoring what the framers intended for Article 368, a comprehensive power. But was it truly just clarifying its power, or was it, as critics might argue, an attempt to grab more power, to effectively bypass judicial review altogether? That's precisely the central tension. Parliament believed it was rectifying a judicial error that had stifled its ability to bring about social change. No doubt about that. However, the very act of explicitly adding constituent power and unequivocally nullifying Article 13 tool for amendments was seen by many, especially those aligned with the judiciary's increasing assertiveness, as an aggressive assertion. An assertion designed to diminish the judiciary's vital role as the Constitution's ultimate interpreter and guardian.
And that distinction between constituent power and ordinary legislative power, that's key, isn't it?
Oh, absolutely crucial. Understanding it is key to grasping the core of this whole debate. Ordinary laws are creations under the Constitution. They are subject to its provisions, including fundamental rights. They can be challenged if they violate those rights. Simple. Constitutional amendments, on the other hand, are acts of constituent power because they change the Constitution itself. They are an expression of the sovereign will that creates or alters the fundamental law, rather than just operating within its existing framework. The 24th Amendment sought to explicitly enshrine this understanding, ensuring that the process of constitutional amendment was recognized as a higher form of lawmaking, distinct from the daily grind of passing regular statutes. Parliament wanted to ensure that when it changed the Constitution, it was seen as operating on a different, more fundamental plane, a plane beyond the reach of routine judicial scrutiny based on Article 13.
Right. But even with the 24th Amendment seemingly clarifying Parliament's immense power to amend, the fundamental question still lingered. It wouldn't go away, a question that cut to the very soul of India's democratic identity. Is there any limit to this power? Really, any limit at all? Can Parliament, even acting with this constituent power, change the very identity, the core principles, the immutable soul of the Constitution? Or are there unwritten inherent limits principles so fundamental that even the most powerful amending body must respect them?
This is where the stage was set for, well, a truly legendary legal performance.
Enter Mr. N.A. Palkivila, representing the petitioner, the solitary religious leader Kesavananda Bharati. Palkivila stepped into the constitutional arena with a truly groundbreaking and, frankly, eloquent argument. Known for his electrifying courtroom presence, his unmatched legal acumen, he carried the hoax of not just his client, but arguably the very soul of the Constitution itself. His central contention was profoundly simple yet revolutionary. The word amendment in Article 368, no matter how broadly interpreted, cannot possibly mean the abrogation or destruction of the Constitution's essential features. It just can't mean that.
Palkivila, with his characteristic eloquence, painted a vivid picture for the court. He argued passionately for implied limitations. This was the radical idea that the amending power, though undeniably wide, could not be used to dismantle or destroy the basic structure or the fundamental identity of the Constitution. He contended that certain fundamental aspects, discernible from the preamble, the overall scheme of the Constitution, and the intentions of its framers, were inviolable. To help us understand this, he offered that powerful, enduring analogy. You can amend a building, right? Add new rooms, change colors, alter its facade. But you can't demolish its foundation and still call it the same building. Similarly, he argued, the Constitution has a fundamental foundation, a basic structure that cannot be dismantled without changing its very essence, without it ceasing to be the Indian Constitution.
That's a powerful image, the foundation of the building.
It is. And what's truly fascinating here is how the court grappled with this abstract but undeniably vital concept. The 13 judges face the immense challenge of finding a way to balance parliamentary sovereignty, the will of the elected representatives, with the idea of enduring constitutional values that should transcend any temporary political majority. This is not an easy task, let me tell you. It led to some of the most intense and lengthy deliberations in judicial history, a truly intellectual and philosophical wrestling match within the highest court.
And after all that deliberation, after weeks of intricate arguments and intense internal debate, Chief Justice S.M. Sikri, in his leading majority view, articulated what he believed were the key features of this basic structure, features that could not be abrogated or destroyed. He didn't offer an exhaustive list, importantly, but rather enumerated core principles, providing a framework that has guided Indian constitutional law ever since. These included the supremacy of the Constitution itself, the Republican and Democratic form of government, the secular character of the Constitution, the separation of powers between the legislature, executive, and judiciary, and the federal character of the Constitution. He also powerfully emphasized that this structure is built on an even deeper foundation, the dignity and freedom of the individual. He saw that as being of supreme importance, beyond destruction by any amendment.
A foundational list, even if not exhaustive.
If, say, the secular character of the Constitution wasn't protected by this doctrine, what could that practically mean for citizens from minority communities, or for the very fabric of India's diverse society? What are the real-world stakes here?
The stakes are incredibly high. It could mean a radical transformation, really. If secularism, for instance, were not deemed part of the basic structure, a simple parliamentary majority, perhaps swayed by a particular political ways or ideology, could theoretically amend the Constitution. They could declare India a theocratic state, or privilege one religion over others. This would fundamentally alter the rights and protections afforded to minority communities, undermining the very idea of India as a diverse, pluralistic nation where all faiths are treated equally by the state. The basic structure doctrine, by enshrining secularism as inviolable, acts as a firewall against such a radical and existential transformation. It preserves the founding vision of the Republic.
A firewall, that's a good way to put it.
And the preamble, that beautifully crafted introductory statement to the Constitution, played a pivotal role in this understanding of the basic structure. Chief Justice Sikri highlighted that the preamble outlines the objectives of the whole Constitution and expresses what we had thought or dreamt for so long. Crucially, he pointed out that the preamble was expressly voted to be a part of the Constitution by the Constituent Assembly. This corrected earlier court views that had stated otherwise. This detail is immensely significant because it imbues the preamble with legal authority, not just aspirational value. It meant the preamble wasn't just flowery language, but a guide, a compass for interpreting the entire document.
So it wasn't just an introduction, it was part of the law itself.
In essence, yes. It was seen as embodying the fundamental concept of sovereignty being in the people, a declaration of democratic intent. And interestingly, it was adopted last by the Constituent Assembly, not first, precisely to ensure its conformity with the Constitution's ideals after all the other provisions had been debated and approved. Judges like P. Jagan Mohan Reddy further clarified the view of the American legal scholar Joseph Story. Story stated that the preamble can expound the nature, extent, and application of the powers and prevent an obvious absurdity or to a direct overthrow of the intention expressed in the preamble. This meant the preamble wasn't a source of power itself, but it was a crucial guiding light for interpreting the limits and purpose of all constitutional powers, including the amending power, ensuring that no amendment could contradict the fundamental spirit it proclaimed.
But of course, there were incredibly strong and passionately argued counterpoints against reading any implied limitations into the amending power. The respondents, including the then Attorney General, fiercely argued that if the framers had intended such sweeping limitations, they would have been explicit about them in the text. It's a powerful point. Why should judges invent limits not explicitly stated by the people who drafted the Constitution?
It really goes to the very core question of constitutional interpretation, doesn't it? Is a constitution only what's written on the page? Or does it have an unwritten spirit, an implied compact, a sort of genius that transcends mere text? The proponents of unlimited amending power argue that a constitution must be elastic, a safety valve even, to prevent violent revolutions by allowing the people, through Parliament, to adapt to changing times and evolving social needs. They quoted that powerful idea that no single generation can bind the course of the generation to come, emphasizing that each generation should have the power to shape its own fundamental law. To them, for judges to suddenly discover implied limitations was dangerous judicial activism. a potential judicial overreach that would undermine democratic accountability and turn the Constitution into an arena of legal quibbling, rather than a dynamic instrument of governance. They saw it as judges essentially making law, rather than simply interpreting it, which in their view was a direct threat to the separation of powers itself, giving unelected judges undue power over elected representatives.
So it wasn't just about ambiguity in the text. It was really a fundamental philosophical disagreement over who holds the ultimate authority in shaping the nation's future, the elected legislature or the unelected judiciary.
Precisely. And they reinforced this argument by citing comparisons to other constitutions. Many foreign courts, like the U.S. Supreme Court in the Sprague case, had rejected similar arguments for implied limitations on amendment powers. They felt that if there were no express limitations, then no such limitations should be read in by the courts. The minority in Kesavananda Bharati emphasized that the power to amend must be plenary, meaning full and absolute. Otherwise, the Constitution would become too rigid, unable to respond to the aspirations of a changing society. They viewed an unlimited amending power as essential for the peaceful evolution of the nation, allowing it to transition towards a more egalitarian society without resorting to extra-constitutional needs. This highlights the deep philosophical divide on the very nature of constitutional governance and the balance between stability and flexibility.
Okay, moving on from the broad question of amending power, we now come to a specific legislative response from Parliament that was also fiercely challenged in Kesavananda Bharati, the 25th Amendment Act of 1971. This amendment didn't just target the general amending power, it aimed directly at overcoming previous judicial interpretations, particularly regarding property rights. Parliament felt these were significantly hampering its ability to implement essential socioeconomic reforms. Here's where it gets really interesting, as the government tried to push through its agenda for a more equitable society.
A very direct piece of legislation.
Let's first look at Section 2 of the 25th Amendment. This specifically focused on amending Article 3.1, the constitutional provision concerning property rights. The most significant change introduced was the replacement of the word compensation with amount for property acquired or requisitioned by the state. Now, this might seem like a subtle semantic shift, just changing a word, but its purpose was profound, to make it explicitly clear that the adequacy of the amount paid for acquisition would no longer be subject to judicial review.
This was a direct, almost immediate response to cases like the bank nationalization case, R.C. Cooper v. Union of India, in 1970. In that case, the Supreme Court had struck down the Bank Nationalization Act, not because the government couldn't nationalize banks, mind you, but because the compensation offered was deemed inadequate and therefore illusory. Parliament felt this was an undue judicial intrusion into policy matters, effectively stalling its reform agenda. By changing compensation to amount, the government sought to ensure that social objectives like nationalization or land redistribution weren't perpetually stalled or entirely thwarted by individual property claims demanding market-rate compensation.
So what this means for you, the learner, is that this was a direct challenge to the interpretation of property rights. It sought to give the state more leeway in pursuing vital land reforms and nationalization without lengthy legal battles over what constituted fair market value. Battles that often delayed or derailed these policies. However, a crucial limitation remained, which is often overlooked. Courts could still review if the amount was illusory, arbitrarily fixed, or based on irrelevant principles. It wasn't a complete surrender of judicial review. The courts still retained power to check if the amount offered was a fraud on power or an illusory return, ensuring some basic fairness.
Indeed, the nuance here is vital. It wasn't an absolute removal of judicial oversight, but a significant narrowing of its scope regarding the financial adequacy of property acquisitions. Parliament wanted to move from a market value-oriented compensation to an amount that could be determined by legislative policy, reflecting social priorities rather than just individual loss.
But the truly contentious and arguably most powerful part of the 25th Amendment was Section 3, which introduced a brand new Article 31C into the Constitution. This article was designed as a potent legislative tool, enabling Parliament and state legislatures to pass laws to give effect to certain directive principles, specifically those in Article 39B and C. These principles are about crucial social goals, distributing material resources for the common good and preventing the concentration of wealth and means of production to the common detriment. Big socialist ideas.
Very much so.
And here's the kicker, the part that truly ignited the constitutional firestorm. Article 31C included an immunity clause. It unequivocally stated that any law passed to implement these specified directive principles shall not be deemed to be void on the ground that it is inconsistent with, or takes away or overbridges any of the rights conferred by Article 14 equality, Article 19 freedoms, or Article 31 property. Beyond that, there was an even more audacious declaration clause. If a law contained a declaration that it was for giving effect to these principles, then no law containing a declaration that is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. Basically, if Parliament said it was for those principles, courts couldn't even check if it actually was.
Wow, that second part is quite something. It raises an absolutely fundamental question about the inherent tension, almost a philosophical divide, between fundamental rights, which are justiciable individual rights you can enforce in court, and directive principles, which are non-justiciable state policy goals, essentially aspirations for governance. Granville Austin famously described Parts 3, fundamental rights, and 4, directive principles, as the conscience of the Constitution, meant to supplement one another, working in tandem. It's fascinating to note that during the drafting process, the Constituent Assembly had explicitly rejected proposals to subordinate fundamental rights to directive principles. That indicates a clear intent for them to exist in harmony, not in a hierarchy where one could easily override the other.
So Palkavela must have had a field day with Article 31C.
Oh, absolutely. Mr. Palcavella launched a scathing and comprehensive attack on Article 31C. He didn't mince words. He labeled it a blank charter, a carte blanche that allowed Parliament and state legislatures to create what he dramatically called constitution-breaking laws. He argued that it fundamentally subverted no less than 7 essential features and effectively destroyed 10 fundamental rights, including crucial protections like freedom of the press, which falls under the broader Article 19.1 right to freedom of speech and expression, and the all-important right to equality, Article 14.
So he was arguing that 31C wasn't just amending, it was dismantling core components of the Constitution. And he also pointed out 2 other critical dangers, didn't he?
Indeed, Palkhivala argued that Article 31C amounted to an illegitimate delegation of constituent power to state legislatures. He contended that by allowing state assemblies to pass laws immune from Articles 14, 19, and 31, they were effectively being empowered to amend the Constitution by a simple majority, completely bypassing the stringent special procedures laid out in Article 368 for constitutional amendments. This was seen as a dangerous subversion of the constitutional amendment process. Furthermore, and perhaps most critically for the judiciary, the declaration clause within Article 31C completely removed judicial scrutiny over whether a law genuinely served the specified directive principles. Palkhivala contended that this absolute removal of judicial review was a core violation of the basic structure, particularly the principle of the separation of powers and the judiciary's role as a final interpreter of the Constitution. He powerfully warned that such unbridled power could also significantly impact the rights of religious, linguistic, and cultural minorities guaranteed by Articles 25-30, creating a pathway for majoritarian laws that circumvented fundamental protections.
The respondents, representing the state, on the other hand, staunchly defended Article 31C. What was their argument? They argued it was not a radical departure, but was similar in spirit and design to existing provisions like Articles 31A and 31B, which had already been upheld by the courts. These earlier articles also carved out specific legislative fields from fundamental rights challenges, primarily to facilitate land reforms and other socioeconomic changes.
Right. They asserted that Article 31C was absolutely necessary for achieving the fundamental vision of a welfare state and an egalitarian social order promised by the Constitution. To them, the directive principles were not mere ornaments but foundational goals, and Parliament needed effective tools to achieve them without constant legal impediments. They advocated for a harmonious construction of the Constitution, arguing that fundamental rights could, and in certain circumstances should, be abridged in certain respects to implement the directive principles effectively, thereby achieving a greater social good. They saw it's a balancing act where collective welfare might, at times, necessitate a limited curtailment of individual rights to build a more just society.
The judicial verdict on Article 31C in Kesavananda Bharati was, once again, a very close split, reflecting the profound disagreements on the bench, a tense 7.6 majority. The court ultimately upheld the first part of Article 31C, validating the immunity granted to laws implementing Article 39B and C from challenge under Articles 14, 19, and 31. This was a significant win for Parliament, allowing it to continue its path of socioeconomic reform and prioritize collective welfare goals.
However, and this is absolutely critical for understanding the lasting impact of the judgment, the court struck down the second part, that highly problematic declaration clause, which made the legislative declaration final and immune from judicial review. Justice H.R. Khanna's swing vote was pivotal in this decision. His unique position, upholding the basic structure while also giving Parliament more power than some of his colleagues, was the crucial factor. The court's rationale was clear. It had to retain the power of judicial review. They needed to be able to ask, is there a real connection, a direct and reasonable nexus between this law and the social principles it claims to serve? Or is Parliament merely using these principles as a shield for arbitrary action? The power to completely destroy judicial review, in their view, violated the basic structure of the Constitution, particularly the separation of powers and the judiciary's role as guardian of the Constitution.
Right, so that severability was pivotal. It meant that while Parliament could legitimately pursue socioeconomic reforms, the courts could still act as a vital check against arbitrary or mollified bad faith legislation disguised as policy implementation. This is the enduring legacy for you, the learner, the judiciary drawing a crucial line, ensuring that even in the pursuit of social justice, the fundamental checks and balances of the Constitution remain intact. It's a testament to the idea that no power, not even the power to amend, can be absolute or operate without scrutiny. The judiciary asserted its role as a gatekeeper against potential abuse of power, even in the name of noble objectives.
A very delicate balancing act, achieved by severing the problematic clause.
Okay, briefly, let's touch upon the 29th Amendment Act of 1972, which was also part of the Kesavananda Bharati challenge, though it played a slightly different role in the overall constitutional drama. This amendment had a very specific practical purpose. It added two Carroll Land Reforms Amendment Acts to the Ninth Schedule of the Constitution.
Ah, yes, the Ninth Schedule.
Now, what's crucial here is understanding the unique, almost mythical power of the Ninth Schedule, especially when read with Article 31B. Essentially, laws placed in the Ninth Schedule are meant to be immune from judicial review, even if they appear to violate fundamental rights. Article 31B explicitly states that such laws shall not be deemed to be void, on the ground that such act is inconsistent with or takes away or abridges any of the rights conferred by any provisions of this proponent. So for governments, this was a highly effective and oft-used way to protect crucial legislation, like sweeping land reform laws, from being challenged in court and getting bogged down in lengthy legal disputes.
This specific use of the Ninth Schedule was a direct response to the immense pressure for land redistribution in states like Kerala. Land reform acts, which aimed to break up large estates and redistribute land to the landless, were constantly challenged in courts, often by wealthy landowners invoking their fundamental right to property. These legal battles frequently bogged down government efforts, frustrating the political will for social change. The Ninth Schedule became Parliament's ultimate tool to fast-track these reforms, effectively saying, these laws are too important for the public good to be delayed by individual property rights challenges. The 29th Amendment, by adding these two specific Kerala acts, represented a continuation of this political strategy, an attempt to make those particular reforms bulletproof from court intervention.
So it was about shielding specific laws.
Exactly. And what's fascinating here is that while the 29th Amendment itself was upheld in Kesavananda Bharati, largely due to the settled nature and long-standing acceptance of Article 31B at that time, the broader question lingered. The question of whether laws placed in the Ninth Schedule after the Kesavananda Bharati judgment are entirely immune from basic structure review. Well, that remains a complex and intensely debated point of law even today. The court in Kesavananda did not extensively challenge the 29th Amendment's validity directly. It focused more on the general amending power and the 24th and 25th Amendments.
So even after the basic structure doctrine was established, the Ninth Schedule still posed a unique challenge to the judiciary's newfound power. Did the court eventually revisit this bulletproof immunity?
Indeed it did. And this is where the dynamic nature of constitutional interpretation really shines. The subsequent evolution of the basic structure doctrine has continually revisited the extent of this immunity. While laws placed in the Ninth Schedule before April 24, 1973, the date of the Kesavananda judgment largely retained their blanket immunity. The Supreme Court, in later landmark judgments like I.R. Coelho v. State of Tamil Nadu in 2007, clarified something very important. They clarified that any law added to the Ninth Schedule after that pivotal date could be subjected to judicial review on the grounds of violating the basic structure of the Constitution. This was a powerful reassertion of judicial supremacy, ensuring that even this seemingly impregnable legal black hole couldn't be used to circumvent the fundamental identity of the Constitution indefinitely. It's a testament to the idea that the basic structure concept is not static. It's an evolving principle that the judiciary uses to protect the Constitution's fundamental identity against any assault, direct or indirect.
So the shield isn't absolute anymore post-Kesavananda.
Not for laws added after that date, no. The basic structure test can still apply. Hashtag tag tag outro, called.
So what does this all mean for you, our engaged listener? The Kesavananda Bharati case didn't just decide a complex legal dispute. It profoundly defined the very nature of India's constitution and continues to safeguard your rights. It struck a delicate and intricate balance. Parliament, representing the will of the people, has vast power to amend the Constitution to meet the evolving needs and aspirations of society. But, and this is the crucial monumental takeaway, that power is not absolute. It ensures that while the Constitution can adapt to changing times and societal needs through amendments, its core identity, its basic structure remains inviolable. This judgment stands as a powerful sentinel, safeguarding the very essence of the Indian Republic against arbitrary changes and ensuring that the foundational principles upon which the nation was built endure.
And this raises an important question, I think, about the profound vision of the Constitution's framers. They meticulously crafted a document aiming for an egalitarian society that respects the dignity and freedom of the individual. The basic structure doctrine is a judiciary's ultimate and most powerful tool to safeguard this original commitment, ensuring that those foundational promises are never extinguished. It's a powerful reminder that a constitution is a living document, constantly adapting, yes, but one with a soul, with foundational principles that cannot be diminished or destroyed by the whims of a temporary political majority, no matter how large. This ensures that the fundamental promises of democracy, secularism, and individual rights enshrined in the preamble remain your enduring inheritance, protecting the ideals upon which the nation was so carefully constructed.
A living document, but with a protected core.
Exactly. And maybe reflect for a moment on the implications of a constitution with no unamendable features at all. Would the sovereign democratic republic you live in truly be secure if its fundamental tenets, things like democracy, secularism, equality, could be entirely rewritten or erased at any given moment by a simple legislative majority? This landmark judgment ensures that the bedrock principles upon which India was founded will continue to guide its future, inviting you to consider what core values are truly immutable, truly beyond the reach of fleeting political power, in any society that cherishes freedom and justice.